All right. Good afternoon, everyone, and thank you for joining today's webinar, When the IRS Comes Calling, What Every Nonprofit Needs to Know About Audits. We know that this can be a daunting and intimidating topic, but we decided to do today's webinar to provide you with the tools and information that you need to know in order to act should this issue come upon your organization. If there are any new IS members joining us today, welcome. We are hosting today's webinar as an exclusive benefit to our members, and we do so every month to provide the latest policy developments and their implications for the charitable sector. So again, welcome, and we hope that you will join us for future monthly webinars. As a part of our webinar feature, all lines are currently muted, but we also will pause periodically to take your questions and also encourage your questions throughout today's webinar. Again, we know that this topic can be a bit daunting and can be a big technical. So feel free to share your questions in the questions box and we will tackle them throughout today's webinar. And so with that, I will turn things over to my colleague, Esther Gyory, who is Policy and Corporate Counsel here at Independent Sector, to introduce today's guest and kick off today's discussion. Esther?
Unmute myself. Thanks, Vanna. So again, I want to welcome everybody here, and I'm going to just really quickly say, so why are we talking about this topic now? So audits are not new. They're, I think, something that most of us are kind of aware of. Hopefully none of us have ever gone through, but they're sort of out there, and maybe in the back of everyone's mind, maybe more in the back of your finance person's mind or whoever signs your Form 990s. But this time, right now, we're at a time where there's sort of a lot more attention in the media, fears over the weaponization of the IRS audit process, criminal investigatory process. There's increased scrutiny over the nonprofit sector. And so I think that a lot of nonprofits are just sort of thinking like, well, you know, we never really thought this was going to be an issue, but maybe we should, and are, you know, just wanting to make sure that they've done everything that they can do to be best prepared. And so our two guests today, Maya Hairston and Randall Thomas, are here from Morgan Lewis, and they're going to talk about just sort of demystify the audit process for tax-exempt organizations, and hopefully help you feel like, first of all, you have a little bit more understanding of what an audit is and what it looks like, and give you a sense of what you can do now, what any nonprofit can do in order to sort of be as best prepared for an audit as you can be. I am going to really quickly give a legal disclaimer on behalf of all of us. This is for educational purposes only. This is not legal advice. As Vanna said, we have a Q&A box, and so if you have questions about the process or about anything that's shared today, please feel free to drop those questions there. However, if you have specific questions about your situation that you should consult with an attorney about, in fact, later on, we will talk about how you can find an attorney if you don't already have one. So with that, I'm going to turn it over to our panelists.
And thank you, Esther. And we'll just quickly introduce ourselves so that our IS members know that they can trust what we're saying here. I'm Randall Thomas. I'm a partner at Morgan Lewis. I joined last October after spending 6 years at the IRS's Office of Chief Counsel in the Employee Plans, Exempt Organizations, and Employment Taxes Division. I left there as a special counsel in exempt organizations. So I spent 6 years doing that. 6 years prior to that, I worked at KPMG's National Tax Office doing exempt organizations, and now I work at a law firm. So I've worked at accounting, law firm, government, and I've seen IRS audits of exempt organizations from about, I think, all the angles one can. And I'll now let my colleague, Maya Hairston, introduce herself.
Hi, everyone. I'm Maya Hairston. I'm an attorney at Morgan Lewis. I specialize in tax controversy. I've been practicing for about 5 years now. A good portion of my work is helping with tax audit strategy for exempt organizations. It's a pleasure to be here today.
And I'll just say it's very nice to meet all of the IS members out there. I can't see you, but yeah, it's nice to meet you. I hope this is helpful. And I've been familiar with the organization since before I became a lawyer. While I was in law school, I was doing pro bono work with them. So we're going to start, and I can't, Esther, I can't see the slides on our screen, but, and I don't know if we're supposed to or not, but okay, perfect. Thank you. Great. So understanding IRS audits. The IRS community includes nonprofits, foundations, philanthropic partners, and I'm going to keep this, and my understanding is a lot of non-attorneys, so we're going to keep this vocabulary pretty practical today, and we're going to be focused just on the federal IRS civil audit process. As you all likely know, you have state charity regulators, grantors, other agencies that can raise separate issues. But today we're going to focus on just a bread and butter IRS audit of an exempt organization. And this process would look very similar as between an organization, a private foundation, a public charity, a 501c4, although the particular technical matters that the IRS might be going after are going to be distinct as between these separate species of exempt organization. It's all going to generally follow the same process. And just in case I forget to say this at some point in this conversation, I do want to remind people that the IRS is just a lot of people, and they're generally pretty reasonable people. There are, having worked there for, like, having worked with them on the outside a lot and having worked there, they are generally not out to revoke an organization's exempt status. It is usually compliance, and they tend to be pretty reasonable, especially when an organization has some ability to demonstrate that, yeah, we're trying to be compliant. We are not tax lawyers, and we don't have the capacity to hire very good tax lawyers, but we've tried nevertheless. They can be quite reasonable, and it's, they can be quite reasonable. So our goal today, we're just going to demystify what happens from the first letter through appeals and in rare cases court. And the main message is simple, and that is that an audit is a process. It's not a verdict. And important here is preparation and consistency. And that's often going to determine how disruptive it becomes. We can go to the second slide now, please. So why do we care? Because the IRS doesn't only audit the return; it's going to audit. It's going to look to how the organization actually operates, and that's somewhat distinct from non-exempt organizations, or perhaps more impactful or meaningful for non-exempt than it is for non-exempt organizations. And the consequences of an audit, they can be financial, tax, additional taxes, interest, penalties, excise taxes, and you can have structural issues too. If the IRS looks at your organization, and maybe you got your exempt status 30 years ago, and maybe as organizations do, you've evolved and you're engaged in a new activity, and everybody was under the impression that this did further my organization's C3 purpose, and the IRS disagrees. So you may also, in some instances, need to make structural or governance or operational changes and take corrective action to ensure that the organization maintains its continuing qualification as a 501c3. Most serious outcome, obviously, is going to be revocation. Well, actually, it could get worse, but that involves criminality and criminal charges. But civilly, the worst thing that can happen here is the loss of exempt status. That is generally the end for an exempt organization, at least insofar as federal exemption is concerned. That's not a routine outcome. That's quite rare. If you look at the statistics, I would encourage you to, if you just Google IRS statistics and information, we have a whole department over at the IRS called RAS, Research, Analysis, and Applied Statistics, and they compile this data every year such that you're going to be able to see that fewer or less, I believe, than 1% of exempt organizations are audited in a given year, and very few of those are ever revoked. You generally have to be, well, it's a pretty high bar to obtain revocation of an organization. So we can, and I'll just finally say that the best defense for all this, as I alluded to, is consistency. It's the governing documents, the exemption application, the Form 990, the website, the minutes, and your activities should be consistent. What is going to trigger, or what may trigger an audit, is when the organization vacillates as between different activities and reporting patterns and things like this. And that's going to be picked up by the IRS's data-driven search queries and also their algorithms. And they, as of late last year, they're now using much more substantially AI in reviewing returns. Next slide, please. Perfect. So let's see. Actually, can we go back to that last one? I'm sorry, I think I may have skipped a slide. Yeah, so here's our outcomes again, and you can think about this as a spectrum. Most examinations, as I said, aren't going to result in revocation. You could get a no change letter. That's going to close the issues in the years examined, but that is not an endorsement of everything else that the organization is doing. They look at a particular activity. Sometimes you'll hear organizations say, well, it was audited 5 years ago. Well, what did they audit? That is the important question. Did they look at your employment tax? Well, that's a siloed audit. That's issue specific. That's not a campaign audit. They weren't looking at, holistically at everything the organization is doing as concerns exemption, private benefit, these types of things. You could also have corrective action. And as any of our private foundation clients or members know, that involves numerous excise taxes. You could have you could have unrelated business income tax liability. You could have an employment tax. Employment tax is pretty common because it's pretty easy to mess up. And of course, Chapter 42 excise taxes for foundations. I'll just remind the audience that excise taxes also often apply to managers and disqualified persons. Disqualified persons, where you're thinking of an excess benefit transaction or a self-dealing transaction, depending on whether you're a public charity, private foundation, and also as concerns excise taxes generally in the manager capacity. If a manager, and this flows throughout, you'll find this in 4958, the excess benefit transaction statute. You'll also find this in all the Chapter 42 foundation statutes. That those excise taxes apply when you have a foundation manager or a charity manager, and that's generally we're thinking of a director or an officer who approves knowingly and willfully an excess benefit transaction or some other proscribed transaction, knowing that it is that. And finally, we can, not mentioned here is a closing agreement. You could have a closing agreement with respect to which the IRS agrees to settle matters in furtherance of sound tax administration. Finally, you could revoke exempt status, but again, that's rare. So we can go to the next one, please. So as all of our C3 members know, paramount here is that the organization operate exclusively for C3 purposes. And, I won't digress too much, but for our, if we have any C4 members in the audience, that exclusively is parallel in 51C4. Both species of organization must be operated exclusively. What does that mean? Regulations tell us that means primarily, that you're primarily engaged in exempt activities. And the core question there is operational. What is the organization actually doing? You have private inurement, you have excess private benefit. Private inurement's generally a hair trigger. Historically has been a hair trigger. 4958, the excess benefit transaction statute, was intended to relieve that hair trigger and say, okay, well, we don't need to revoke for every time somebody makes a mistake. IRS used to not have that ability. You have failure to, for a Section 501c3 organization, no political campaign intervention, full stop. If anybody's interested in what political campaign intervention means, there's a case currently pending in the DC District Court called Freedom Path. Lots of briefs, generally free to the public. If you're interested in that as concerns your organization, I encourage you to look at that. And I'll just say more broadly that when members and clients and exempt organizations ask what is the view of the government on this, often there's a deficit of recent public information in terms of continuing professional education texts, revenue rulings, whatever the case may be. But if your issue is being litigated, the best indication as to what the United States thinks about a particular issue is what they commit to writing in briefs. It is really a great resource, and I find a lot of people just don't even think to go there. But what have they just presented to the tribunal with respect to a matter that's being litigated? Finally, we have impermissible lobbying. As you all know, C4s can engage in some amount of lobbying, as can C3s. You either look for a C3, you make an election under 501H, or you consider this amorphous concept of whether you're more than insubstantially engaged in lobbying. There are certain exceptions to this in 4911 regulations, but generally, we don't want more than insubstantial lobbying. failure to file required annual returns. I'll point that out just because I encourage everybody just to ensure, go to IRS tax exempt organization search and ensure that your organization, just put it on your calendar once a year. Just go check and make sure that they've posted your 990 or 990 EZ. I say that because there's a statute 6033J that automatically revokes an organization's exempt status when it has failed to file a required information return or notice. So that's your 990, 990N, 990 EZ for 3 consecutive years. And I spend an inordinate amount of time fixing these problems and trying to restore retroactively the exempt status of organizations who had management turnovers and these types of things, and they failed to file the returns. So I really encourage you to do that. It's just, doesn't have to be a lot on it. We just have to file it. Otherwise, that is a hair trigger, and the IRS can't do anything about it. And then you have to go in and apply and also seek reasonable cause relief such that you don't have an interruption in your exemption. Well, I'll just briefly mention illegality. I don't expect this to be the case for, go ahead.
Sorry, Randall, we have a great question in the chat. If
Sure.
they do go and look and see that the IRS hasn't published their Form 990, what should they do?
Yeah, so if I have, without getting too into the weeds, let's just say I'm a calendar year organization, my return is due May 15th, and let's say I'm a public charity too. My return is due May 15th, my extended return is due November 15th. That only works if I actually file my extension. I think that's Form 8868, don't quote me on that. But if you have done those things and you get through November, and you filed as of November 15th, you're timely extended, and you go and look in December or January, and it is still not posted there, there's an exempt organizations hotline, and you will also find there's a particular, well, I actually wouldn't go there. I would start with the exempt organizations customer service. If you Google that, you will find, I'm not going to go and look it up myself so that I can pay attention to this, but you will find not only a number, which you may not have success with because the IRS has lost 30% of its employees in the last year and a half, and it was historically bad at picking up the calls, and they also can't solve that much. What I would do is I would write a letter. I would send it certified mail. I would, if you have an attorney or a CPA working with you, I would include that power of attorney, that Form 2848, and I would explain what I'm looking for. I filed. Here's my e-filing receipt. Here's this evidence that I have sent this to you. I don't see it there. Just checking to make sure you got it. And I'll just caveat that by saying I check IRS tax exempt organization shirts just to see that everything is working like it should. And it doesn't always. If they don't post it, it doesn't mean that there's necessarily a problem. You all have proof that you filed it. That is the most important part to keep in your records. But I would start with that and we have to do that pretty much all the time. These little nits to help the IRS. Oh, you missed this, and you think that this organization isn't eligible to receive tax deductible contributions. Of course it is, and here's why. Please correct your records. And I'll just briefly mention illegality. I don't suspect that many organizations here are engaged in illegality, but illegality can include everything from material support of terrorists, designated terrorist organizations, or something as minor as encouraging people, and this is a classic revenue ruling. I think it's 75-384 if anybody's interested in looking at it, but it could include directing one's members to obstruct traffic. That is something that is, without getting into the weeds, that has been a particular focus of this administration. There's in fact an executive order that speaks to the obstruction of traffic. So there's a concept of substantiality. If you are doing anything, and it's not always clear the degree to which something is illegal or whether it's illegal at all, I would encourage you to consult with counsel. And we can go to the next slide now. All right. So a routine exempt organization audit is going to be civil. We're not going to talk about criminal today. It generally, as you all might suspect, we require mens rea. You need a guilty mind. You need willfulness, fraud, false statements, obstruction, a diversion of the organization's assets, and some species of intentional misconduct there. And as Esther described earlier, without dwelling on politics, the practical point there, I think, is that nonprofit funds flows, especially inbound, outbound, and potential tax crimes, especially how an organization reports its activities. When you sign that 990, you are telling the government that it is true and complete to the best of your knowledge under penalty of perjury. Mistakes happen. Pretty much all exempt organization returns have a mistake in them. That's fine. But you cannot, as you all know, and I'm sure nobody does, if you just cannot take an incorrect position knowingly on a tax return. I would talk to counsel if you have any temptation to do that, because maybe you think it's a construction of law. If it's ever dicey, you have to paper that. I would do it internally. I would do it with outside counsel. Say, this is our position. We sincerely and reasonably believed that this wasn't a problem. Things like that. The IRS, as I noted, it is now using AI and network analysis to identify relationships and indicators of suspected fraud for civil and criminal referrals. These red flags include, fabricated records, false statements to government officials under Title 18 USC 1001, a diversion, things like that. Your normal audit's just going to start with a letter. A visit from criminal agents or the execution of a warrant is a different event, and that should immediately trigger white-collar counsel. It's very unusual, unlikely that's going to happen, but your staff should be, and I've seen different roadmaps for how to handle this, but generally staff should understand that naturally, you're polite, you're responsive, you identify the agents, the legal process, you avoid substantive interviews, and then you go and contact your counsel, you preserve documents, and you never obstruct and you never destroy anything. But the first step really is getting an attorney involved so that you can get privilege, so that you can maintain privilege. Next slide, please. I'm just going to skip over this a little bit. This had a lot more attention last year when I was at the IRS. We had our president at that time tweeted about certain universities, and there was there was significant concern in the exempt sector that maybe the government could they just come in and revoke my exempt status? Do they not have to audit me? Is there not some process required? And as I believed last year, I continue to believe that is a silly idea for the government to try to do. I don't know that they ever sincerely considered it, but I certainly did. And without getting too into the weeds, you would run into a number of substantive legal hurdles, one being due process, another being it's a violation. I feel pretty strongly it's a violation of the Administrative Procedure Act, because here you have an agency action that would be arbitrary and capricious and unsupported by a record. Beyond that, and those operate independent of whether you're an exempt organization or not, but beyond those things, you generally need an audit. You don't have a record, a basis with which you could do anything to an organization or an individual under an audit, absent a record. You can't just go into court and say, revoke them. That doesn't, well, you're not going to start a court. You would revoke at the administrative stage with the IRS. And then you go to court, and this is all pointless for the government because it's going to immediately get thrown out on a motion for summary judgment. I'll just note that the typical process is that you do have an audit, that substantive revocation follows an examination and a proposed adverse determination, and then an opportunity for administrative review. We get to submit a protest, and we go to appeals, things like this. I won't really speak to retroactivity of revocations. Big point there is 7805, a particular statute protects an organization's exempt status from retroactive revocation, which would involve, for example, going back to formation in some cases and saying you've got to file 1120s or some other type of tax return. And also you might have back taxes, things like that. That's very rare. If the secretary does it, you usually raise an abuse of discretion argument, but it's very rare because of this particular statute. If we haven't lied, if we didn't materially misrepresent anything in both our application and our 990 subsequent to that, it's very unlikely that any organization will ever get retroactively revoked. We can go to the next page, please. So this is probably useful to keep in your pocket if your organization, if the IRS ever proposes revocation, and its impact of revocation on donors. A donor can always make a gift. What often matters to them is charitable deductibility as a charitable contribution. If the organization goes to court, if you file a declaratory judgment action under 7428, you have certain rules. Basically, individual donors capped at $1,000. Charitable contributions from, for example, other public charities are not subject to the $1,000 cap. But if, for example, it's a private foundation, it may need to exercise expenditure responsibility or find another qualifying structure. And the important part here is communication with donors. And it's kind of the same communication as when an organization incorrectly gets erroneously automatically revoked for failure to file. But, we have proof that they did file. So by operation of law, that doesn't work. Donors will say, well, it looks like you've been revoked. And you produce the evidence, say, look, this is actually how the law works, notwithstanding that. And we're trying to get that cleared up. The same thing here. It's education for donors. So we can go to slide 8, please. Perfect, thank you. So selection of exams, you can imagine that's not random. Form 990 data allows the IRS, and as you all know, because you prepare your own 1040s and some of you prepare 1120s for corporations, things like that, this is an information return. You provide a significant amount of information to the IRS with respect to which you can imagine what AI is going to do to this in coming years. Setting aside that the IRS still maintains its computer mainframes in Martinsburg, West Virginia, and it's still about 40 years behind in technology, but they are now using AI. They're using it for rulemaking, drafting guidance, as well as exam audit selection, and it's just so powerful for looking at these returns and saying, well, that doesn't match that, and this doesn't match that, and here we would expect this by reason of this debt situated over here, things like that. So use a Form 990, algorithms, AI, inconsistent answers year over year on the 990 or the 990T. You can always have third-party referrals. Sometimes they're genuine. Often it's an aggrieved former director or employee or some other competing organization or somebody who just doesn't like what the organization is doing policy-wise or something, but nothing specifically legal. The IRS often doesn't act on those because it's able to look at the organization and say, we don't see that. That's not there. But it's something to be aware of. You could also have audits arise by reason of an audit of a related person, a disqualified person, a payroll, things like that. And I'll finally note that we have compliance checks as well, and they're just they're not technically exams, but if you provide unsatisfactory responses, it could lead to an actual exam.
Randall, could you just really quickly mention, I wanted to bring up, the prohibition, there's a criminal prohibition on the president and other senior members of the executive branch requesting or directing the IRS to audit a specific taxpayer. So if you want to just maybe.
Sure.
Yeah,
absolutely. So that's 7217 and Title 26, Internal Revenue Code 7217. And that statute generally proscribes and provides that it's unlawful for any applicable person to direct or to request directly or indirectly anybody at the IRS to conduct, to open up, or to terminate an audit or another investigation of a taxpayer. An applicable person for these purposes, that includes essentially the chain of command down from the president into the Treasury. So president, vice president, employee thereof, all the way down, or any individual serving in a substantially similar position. What that statute says, well, it subjects these people to criminal penalty if they direct such an organization, setting aside that kind of selective prosecution, especially being buttressed by that statute, is unlikely to be successful for the government. But that's what that statute says. And you might, if you, not to be a total gossip, but if you want to learn more about this, I think that there was a recent Wall Street Journal story in the past couple of weeks perhaps speculating as to why our most recent Assistant Secretary of the Treasury for Tax Policy left his position pretty abruptly. And we can go to the next one whenever you all are ready. Hopefully that 7217 was helpful. Yeah, so Recent areas of focus, these are public signals of what the IRS is interested in. It's not an exhaustive checklist. Worker classification remains really important because misclassification is common. Sometimes it's accidental. It's often because an employer doesn't want to it doesn't want to treat an employee as an employee, which is why you don't rely on an employer's classification of employees, and you regularly have these audits because employers are often mischaracterizing employees. For organizations, if you have anybody at your organization that gets paid in excess of $1 million a year, and I'm generally speaking to W-2 compensation, and you're also going to take into account like vested long-term incentive plans, things like that, pay close attention to 4960 and really pay close attention to the aggregate amount of compensation paid by not only the organization to that to that employee, that CEO, for example, but also the compensation paid to that person from related organizations, without regard to whether those services are performed for those related organizations. Finally, I'll say, if we have any elective pay credits or hospital compliance, those are high dollar document heavy areas. The IRS tests eligibility, substantiation, and policies, things like that. So we can go to slide 10 now. Yeah. So if you get an audit letter, right, we have to have subject matter experts. We need SMEs with respect to the matters at bar. So you should have an EO lawyer, exempt organizations lawyer, quarterbacking the response and keeping the facts tied to exemption status, viewing all of this through a lens of charitability or exemption generally. You can have and that's what I am mostly. I'm an exempt organizations attorney, primarily. And Maya, on the other hand, she's the next step. She is a tax controversy attorney, and she manages procedure and deadlines and administrative records and understands how we go to appeals, what we put into a protest, how we get into court, substantive issues that generally I might not know how to do. Then you have white collar counsel. If we mentioned this earlier, but if there's any indication that we might have a criminal investigation as with respect to individuals at the organization, you've got to bring in white collar counsel. They're going to understand. They're going to pay particular attention to privilege and any falsehoods or obstructions or search warrants and the validity of the government's procedure in pursuing those criminal claims. You can have constitutional admin law issues. In my last couple of years at the IRS, I was an unwilling constitutional law attorney. I had to do all manner of, national religious broadcasters, Freedom Path is due process, what other ones? Catholic Charities Bureau went to the Supreme Court, those things. So that's, as you all know, uniquely in the United States, our charities administration function is couched within the tax administrator. That's very odd relative to other countries. So you end up with a lot of tax lawyers trying to learn how to do these other things. And it is neat and it's unusual. And you end up with situations like this where exempt organizations lawyers have to, try to understand constitutional law with the support on their side from, I'm pointing to the IRS building behind me, at the IRS with the support of the DOJ, on the outside with the support of our colleagues who understand constitutional law and admin law. And just finality, not every case needs a specialist, needs every specialist. You start with an exempt organizations attorney, somebody who can look at the letter, and somebody who can identify the issues and really frame them. Next slide, please. Yeah, so pro bono resources. Morgan Lewis does a lot of pro bono. I guess we're the third bullet over here. We do a lot of pro bono work. I do a lot of pro bono work here. It's great. I'm not sure how it all works, but the facts are just as interesting. I like large organizations and small organizations, and I just like the issues, and I think we do generally. And there are a lot, beyond us, there are a lot of resources out there. You have legal nonprofits, you have state bar associations, and law firm pro bono programs, and this helps locate counsel for exempt organizations, where you can bring in people like Maya and I, who have experience, different angles of experience with respect to these matters. But even in a pro bono matter, they're still your attorneys. You centralize communications, you preserve documents. It's the exact same process. Finally, one thing that I haven't noted is, with respect to that question earlier, where the person asked, well, what do we do if it doesn't show up on an IRS website? There is kind of a relief valve here. Sometimes it works, but it works often. Sometimes it does not work when I think it should. But that's the taxpayer advocate service. They can help with procedural hardships. It's not a substitute for counsel, but if all else fails, if we're not getting any responses from the IRS and we are confident that we are 100% legally correct, we go to TAS, the Taxpayer Advocate Service, and that's what they're there for, is to help organizations that are just kind of stuck in the machine with the Internal Revenue Service.
And
So
I'll just add, oh, sorry, I was just going to add, if a member ever gets a letter or anything from the IRS or has a question, they can contact us and we can help put you in touch with counsel, whether that's pro bono counsel at a law firm or help connect you with State Bar Association or other nonprofit resources.
I will, and I think this is my last slide for the moment. I will turn it over to my colleague Maya.
Thanks, Randall. We can go to the next slide. We can go one after that. I just wanted to say one quick thing about tasks that I used in a pro bono case where even as an attorney, I was not getting traction with the other side and trying to get something accounted for. And I filled out the task form just like anyone else would. And I was linked up with someone from TAS, and we got a more immediate response that I think I would have otherwise. So they can definitely be helpful, and they will call you and they will, answer all of your questions. So that's definitely a good resource. We can move to the next slide. So we'll talk a little bit about the life cycle of an audit and where it starts with the letter and then where it goes from there. One important thing to note is how long does the IRS have to audit me? And it depends, the favorite phrase of a lawyer, but generally they have 3 years from the time the return is filed to assess additional tax. And then they have 6 years in a case of where there's a substantial omission of income. And this bucket typically falls unreported UBTI, unrelated business income tax, where you would file a form 990T. They have 6 years to audit that. And then where there is fraud, there's generally no limitation as it's under the crime bucket. You can go to the next slide. So here's the life cycle of an audit. Visually, it looks long. In real life, it also feels long. I think one thing I like to tell my clients is that we would love for the IRS to be in and out of our hair, but the reality is that they have, they can have upwards of like 30 days to review responses and things like that. So I would say if you are audited, just be prepared for it to take a lot longer than you would hope, and which I know can be frustrated to taxpayers. So step one, you'll get a notification letter. And I think that letter, like really reading the letter is important because of course it's scary. It's from the Internal Revenue Service, like what's going on, what has happened. But to the point earlier that Randall made of like it could just be a compliance check where there's an agent assigned to you and they're looking to make sure that you are compliant with like certain requirements. So for example, I have a hospital client. They were undergoing an audit at the same time. And then for a subsequent year, unrelated to the audit, there was a compliance check where they were trying to make sure that they had uploaded their financial assistance policies and other 501(r) requirements. And we also assisted them on the compliance check, but it was a lot different of a ball game as compared to an audit. So definitely read the letter, see what it says, see what they're asking for, and then find a resource to help you navigate the audit process. So after you get the letter, typically attached to the letter is what we call information document request number 1. And that's going to have some broader questions about the activities of the organization. It may ask you for financial records. It may also ask you for a site visit and an interview with someone who can discuss the exempt organization's mission, purpose, activities. And I'll get more into information document requests, IDRs, and how important they are to the successful resolution of an audit. But those will come throughout the audit. So it's not kind of just like a step 2, it's throughout, because as you can see in step 5, they will issue more follow-ups if they have follow-up questions We generally, if the IRS has follow-up questions, ask them to reduce them to writing, which means they will issue another IDR, but it's best just to keep, everything in writing, and so we can track our responses over time. Number 4 is, it talks a little bit about summons and feeling like, if a taxpayer is not cooperating, that can be the case. So the IRS has a subsequent step after an information document request. They can issue an administrative summons that more or less compels a taxpayer to provide the required documents. This can be because the taxpayer is refusing to provide the documents, but it could also be to protect the taxpayer who potentially has to go to a third party to request documents. Like, for example, an hospital audit, if you might need patient records, like we would request that the IRS issue us a summons so that we could ask for those from the appropriate hospital facilities. So sometimes the taxpayer has an incentive to ask for a summons so that they can have a little bit, I guess I would say we characterize the summons as having a heavier hand in being able to ask for materials because it feels like a more compulsory request from the government. So if we've gone through the audit, we're at number 6. You probably a few rounds of information document request, you've provided materials. Now the revenue agent's going to provide a report. And typically this is the first time in writing where you get to see the examination's position. Of course, we always encourage speaking with the examiner throughout the process to learn in real time, what the issues potentially could be. But this is the first opportunity that you'll see their position in writing. And then we'll get more into 7, 8, and 9 in the subsequent slides. But so for now, yeah, I think that's it. That's what I'll say for this slide. Randall, do you have anything to chime in on?
That was terrific, and I don't have anything to chime on because you are the life cycle subject matter expert.
Thanks, Randall. Okay, we can go to the next slide. So information document requests. I view an information document request as an opportunity to establish our strategy and the theme and the story we would like to tell. Of course, we're always giving truthful responses to these document requests, but it gives you a chance to frame things in a way that are most beneficial to you as an exempt organization and your position. And Randall mentioned this previously, you want to put into focus how the activities are related to your exempt purpose. And so that's going to be a lot of the emphasis of every information document request that you respond to. You definitely want to make sure they're accurate. This is going in the administrative record. So you want to make sure, so I spend actually a significant amount of my time working on responses to IDRs and making sure they align not only with the record in front of us, but also like our strategy in the future. We can go to the next slide.
I'll just say 2 things there. My first, not that you were besmirching my civil service colleagues. A few minutes ago, you say that the IRS takes a long time, but just in their defense, they do take a long time because they are like us, with so many novel and sui generis topics, they are learning these things for the first time. And also they don't, we get great training and we've learned these things for a long time. Just they don't always have that available to them, but they are generally working very hard. And on that last topic, that last slide, it might have said something, I forget what exactly it was, but I just want to impress upon the audience that it is really important to have this right from the beginning. You'll see audits on that at the IRS side where they'll switch counsel midstream or where they'll start trying to respond to an audit and they start messing things up. And it really hamstrings your ability to tell a clean story and the compelling narrative that you want for escaping that without issues. When somebody comes in before you and doesn't actually understand exempt organizations tax law and starts committing things to paper, to writing, and then submitting them to the IRS loves to put that in your face when you get further along in the process.
Yep, definitely agreed that it should be intentional from the beginning in what you're providing in your responses. You can go to the next slide. One thing here that I wanted to point out, and this is like my favorite thing to always point out to the taxpayer, sometimes the IRS will request things that you request business records that you just don't keep. It doesn't make sense for your business to keep those type of records. And the IRS cannot compel you to create business records out of the blue in order for you to respond to an information document request. Of course, if the records exist like disparately and perhaps creating a summary would better answer their question, you can consider whether or not that makes sense. But often I've seen instances where taxpayers have the copious amount of information all over the place, and it's just a burden to try to like put that into one place. And you're not actually compelled to do that. And that's usually where counsel can step in and have a conversation with the examiner about what's the best way we could give you maybe a subset of this data or a skinny down request that would make it not a super huge burden on the taxpayer to respond. Let's see, we can go to the next slide. One other important aspect throughout the entire process is maintaining privilege and knowing what privileges you have. So there's attorney-client privilege, which are communications between an attorney and a client, confidential communications, where the client is seeking legal advice. Those communications should be kept private and confidential. Otherwise, you risk facing waiver, which means the IRS would be entitled to anything discussed. And waiver can occur, it's not on purpose. Sometimes it's accidental, like you're forwarding an email from your attorney to your CPA. If your CPA is not within the privilege bubble, then you've just waived attorney-client privilege on that particular topic. So it's just being mindful about what your communications are about and whether or not they have the privilege. Work product is typically confidential. Work papers prepared by an attorney or their agent that have basically the protection of being disclosed to the other side. And then Section 7525, taxpayer practitioner privilege aligns with attorney-client privilege. It essentially extends it to tax practitioners such as CPAs. And it's important to also keep that in mind because it's a kind of a special privilege to the tax space. You can go to the next slide. So again, we made it to the end of the audit. You saw this slide earlier. Randall did a great job of going over what the outcomes could be, but essentially you've done all the IDRs, you've had conversations with the agent. The agent's gonna issue their revenue agent report, and one of these or a couple of these will be included as an outcome. And then the next slide. So if you disagree with the revenue agent report and what's called a 30-day letter that typically follows, which is like the official position and time clock, you have an opportunity to appeal, to file an administrative appeal. And there's generally two options. There's alternative dispute resolution, and then there's the IRS Independent Office of Appeals. Alternative dispute resolution, this is actually a broader category and has various options underneath, but the way I would say it is you're looking to go, taxpayers looking to go with exam and have a very productive conversation in trying to settle. There's maybe not like a huge impasse or a huge legal issue that's lurking, and both sides think they can reach a resolution. Whereas IRS, Independent Office of Appeals, you're going there because you're in at an impasse, and essentially what you're requesting is that a IRS appeals officer come in and evaluate the hazards of litigation. Hazards of litigation are essentially, if this went to court, which side would win? And they kind of do this like percentage calculation, but that perspective of how this would play out in court influences whether or not the IRS appeals officer will make you an offer for a certain amount, because the next escalation point is a litigation.
And Maya, if I can jump in here, we do have some late breaking news. So this right of appeal that you were just describing to the Independent Office of Appeals, there's some vagueness about whether or not the statute guarantees that as a right to all taxpayers. And so the Senate Finance Committee has been working on legislation that would actually clarify that and make it explicit that that is a right that's available to taxpayers. And just this morning, the Senate Finance Committee advanced the bill out of the committee, and it included an amendment that was offered by Senators Langford and Warnock that we worked heavily on, independent sector, that would actually explicitly include determinations of tax exempt status to that list of situations under which the taxpayer has the right to appeal and requires the IRS to provide notice of that right. And I just want to flag that it is 2:51. We have some questions we want to get to. So if you could talk really briefly about sort of what the next, I know this is in your slides, but what the next step is, if you can't reach some sort of favorable conclusion with the Independent Office of Appeals and you decide you might need to go to court, what that looks like, and then talk a little bit about how organizations can prepare.
Got it. Yep, I can touch on that briefly. And Randall, feel free to chime in. Typically, if you reach an impasse with appeals, they will issue a notice of a deficiency or an official determination. And typically, you can appeal that to the United States Tax Court. Do you have anything specific, Randall, for EOs?
Sure. And I will. I talked too much during my section, so if you, I'll just try to expedite. I think the rest of these are my slides where I'm prime on them anyway. But that's exactly right. If you get through appeals, and I'll just flag that the protest is what I think is generally the most important document to come out of the administrative process before you go to court. Before you get there, it's IDRs back and forth. It's messy, but that protest is a brief. It is the strongest argument. It is the narrative that you present to appeals, which does have settlement authority, which can give away the case. It is a really important document, and it is probably what's paid most attention to in the administrative process, the protest and the IRS's rebuttal once you do get to court. You fail at appeals, they uphold or do not refuse to settle on terms that you find acceptable. Then you go to court. You have 7428. You can either actually, let me pause that. It depends on the type of litigation you're doing or the type of audit you've undergone. If they attempt to revoke if they are proposing to revoke your exempt status, and that's what the IRS tries to do, it's 7428. That statute provides for a declaratory judgment action. You can go to the tax court, the DC District Court, or the Court of Federal Claims for a determination as to the organization's ongoing qualification as a 501c3 or a 501c4 or any species of 501c. Separately, if it's a UBIT audit, you're generally going to go, you go to district court or the tax court, but 7428 is not going to apply to that. You're not going to have the same rights, privileges, and obligations. I will not spend any more time on 7428. We will just hit briefly a couple of, if we could go to slide, yeah, so this is mapped out pretty clearly to you right here. If we could go to slide 22, I'll just hit these next ones really quickly. Yeah, so knowing the organization's risk areas is super important, and a periodic internal review that tests whether your 990 is aligning with what you're publicly presenting and your website and everything else. And finance, legal, program staff, HR, these people should know what their roles are. But before you're audited, they should obviously know what their roles are generally. Next slide, please. Yeah, I think these are going to depend on the type of organization. If you're a hospital, it's 51R and publicization of your financial assistance policy. If you're engaged, if you, for example, have a workforce development program where you're teaching people with certain disabilities how to run a grocery store, that's a classic revenue ruling, something like that, then you should pay attention to certain commerciality indicators to make sure that it's not commercial. And the next slide, please, 24. Yeah, I just obviously know who your disqualified persons are. What is the organization's mission? What did it commit to writing when it applied for exempt status? Because that is the basis for the organization's exemption. That's what determines what is substantially related. Finally, on the next slide, I'll just note that if you find error, I mean, this is just this is a best practice for compliance generally. Take a look at your organization and its return. If you find errors, correct them. It is so much easier to get through these processes, and it is. If you have an excise tax, seek abatement. Make the case that you had reasonable cause for that failure. It wasn't knowing, it wasn't willful. these types of things, but fix things as you find them. And that is, I'll set the mic down, and that I think we've gotten to the end.
Thank you. So just a couple of questions that we got. So one question we got was specifically around resources that organizations and organization leaders could use to understand their audit rights and rights of appeal and all of that. And so I think what we can do is maybe pull some of those together and send them in an email afterwards. But there are out there. The IRS has some, and there are other sources that can sort of walk you through a lot of what's been discussed here. Another question that we got that I'll just answer really briefly, and Maya or Randall, if either of you want to chime in, any thoughts about the illegality doctrine and the DEI restrictions that the administration has been adopting through executive orders? So what I would just say from my perspective is that we haven't yet, we have seen action taken against specific organizations, some pretty high profile stuff. I don't know that we've actually yet seen a revocation that is based on specifically an interpretation of illegality that isn't in line with what what we would have thought. I don't doubt that could happen, and and maybe in process, who knows, but if and when that happens, I would expect that would go to court, and you would end up with judicial opinions on whether or not a given activity or whatever under the statute was would disqualify an organization from getting tax exempt status.
I'm happy to speak to that. I spent a ton of time thinking about this within and without the IRS. If you are interested in, I'll just plug this because it's probably the clearest articulation of what the government believes the illegality doctrine extends to in the last year and a half. And maybe probably the last decade. But if you want to go to my profile on the law firm's webpage, you'll find a write-up and then maybe a podcast link to the Public Service Loan Forgiveness, the PSLF, proposed and final regulations. They were finalized last Halloween. I found those especially interesting because the Department of Education tried to adopt the illegality doctrine for purposes of determining whether an organization is a qualifying employer within the meaning of the PSLF statute. That you'll see that derives, somebody mentioned executive orders, that comes from an executive order from the president saying, I want the Department of Education to promulgate these regulations. And then it names like 6, I think, categories of bad acts or illegal acts that would deem the organization, or we presume the organization, to be more than insubstantially involved in illegal activities. They are what you would expect. It talks about trans things. It talks about blocking roads. It talks about facilitating illegal immigration, the things that we know that the administration cares about. They adopted that as a final rule last October 31st. 2 district courts invalidated those rules on June 30th, 2026. So about a week before they were supposed to go into effect. So that's exactly what that should look like. The government, as bizarre as it sounds, the Department of Education adopted an IRS doctrine and tried to apply it for purposes of qualifying PSLF employers. And a court said, that's arbitrary and capricious. You don't have any basis in law. It's also a due process problem. And finally, it's extra statutory. The statute itself, the PSLF statute, does not provide any such qualifying language. So that's what I will say, is that it's a doctrine. The IRS doesn't really use it. In the obvious common sense reason why they don't is because the IRS has no particular competence with respect to illegality outside of tax. We don't know what it means to be illegally doing immigration or anything else like that, and they never should. You might follow up the DOJ with an investigation. So,
thank you for that. Well, thank you both very much. This has been great. I am going to hand it back over to Vanna Cure to wrap us up and talk about what we're going to be doing next month.
Perfect. Thanks, Esther. And thanks again, Randall and Maya, for joining us. Lots of information there that I hope folks walked away with some good resources that they can take to their own organizations. And as Esther mentioned earlier, if we can be helpful with pointing you all in any direction, please feel free to reach out. A couple things to mention, of course, IS's National Summit is coming up in October 13th through the 16th in Phoenix, Arizona. If you haven't already done so, please register for that conference. And then just also a reminder that we are hosting a pre-conference as we started last year, the Policy Professionals Advocacy Intensive for experienced policy professionals. Esther and myself will be there leading sessions, but that's absolutely free for IS nonprofit members to include that add-on with their summit registration. So please register for PPAI as well. And Esther, as you mentioned, directions for August, we are actually true to our tradition, taking August off from MPU. So we will not have a monthly policy update in August, but we will see you all back in September for our next monthly policy update. Again, thanks so much, Randall and Maya, and you all have a great rest of your day.
Thank you for having us.
Take care, Randall.